Okay, with 1 minute to go, I'm going to go. Oh, we just turned. I am still, my spirit is feeling very full after our Abundant Table service today. It was really joyful and beautiful. And I was tempted to start by saying something a little bit goofy and saying, okay, we're going into a different mindset. But in the Episcopal Church, we are not going into a different mindset. We're doing end-of-life planning. And we remember that the liturgy for the funeral is an Easter liturgy. And today we're talking about planning for the end of our lives. But we do that in joyful hope of the resurrection. The rector, you may not know this, but the rector or the dean has very few specific responsibilities by canon. But one of them happens to be teaching our church members about the importance of making a will. We can expand that to include end-of-life planning that ranges from healthcare directives to funeral planning. That means what we're talking about today, which sounds at first like we're talking about financial or funeral planning, is really about pastoral care and about living with hope in the promise of the resurrection. So it's a round table covering lots of ground, so we're going to hop right to it. I am pleased to welcome familiar faces, our member panel that includes the Reverend Dr. C. Eric Funston, a retired Episcopal priest. He's not retired as a priest, but he's no longer serving a parish as a rector. He is active in the liturgical life of Trinity Cathedral and served most recently as the rector of St. Paul's, Medina. He'll offer theological and pastoral guidance on preparing a funeral. The Honorable Ute Vilfroy is the retired magistrate and court administrator of the Ohio Court of Appeals, 8th District. Will speak to us about the importance of making a will. Amy Ryder-Wentz is a shareholder with Littler Mendelsohn and represents employers in just about all things employee-related and will offer the pros and cons of trusts. And Marie Curry, J.D., M.P.H., it's Masters of Public Health, is a lawyer with a focus on health policy and public health. Her day job is as managing attorney at Community Legal Aid in Akron. She'll talk about advanced directives, living wills, and healthcare power of attorney forms. One note, we're going to talk about a lot of things, and some of the documents that we reference will be made available afterwards. So please don't feel like you have to capture the verbatim writing down right now. You have a lot of that in front of you, so take notes that you want, but understand any information can be made available to you. So we're going to hop right to it, and I'm going to start with Eric. Eric, welcome.
Okay. I don't have three hands. So. Anyway, halfway through your packet is this little thing called Planning a Celebration for the End of Life, Final Celebration of Life. Just by way of intro, when Cheryl asked me to do this, actually she asked me to do something on estate planning and probate, and I said I haven't practiced law for 35 years, so I don't know anything about that anymore, but I'll be happy to talk about funeral planning, so here we are. I think BJ and the other clergy here would agree with me that when we do a funeral, frequently people who are not members of the Episcopal Church will come up and tell us how lovely the service was. And when I get those compliments, I just deflect them and say, well, you know, that's the beauty of being in the prayer book tradition. We just follow the recipe in the cookbook. But it's actually a little more complicated than that. And planning a funeral, particularly with a large family of survivors, can sometimes be a source of conflict in the survivor family. So I think that one of the best gifts you can give your family is to plan your own funeral so they know what you want. I had the joy of presiding at my mother's funeral, and she planned the whole thing, and it was great that I didn't have to deal with any of that. So anyway, you have this form in the packet there, which has a 1 or 2 page introduction, and then the form itself, which I'm going to recommend that you can use to plan your own funeral. But there's more to it than just filling out a form. The first thing I would recommend that you do is on the first 2 pages of this are a whole bunch of questions. I would recommend that you write a letter to your family answering all those questions and telling them about your life and the things that are important to you and what went into your thinking in planning the service. And then BJ stole my thunder, the first. That machine. Huh? It's not working. Oh, please work. It worked earlier. Let's go to the next slide. Next slide. BJ stole my thunder when he said that we're talking about joy here. This is from the prayer book that the liturgy for the dead is an Easter liturgy, so it should express our joy and hope of the resurrection. Let's go on to the next one. I'm not going to spend a lot of time on any of these slides. Okay, there's the write a letter slide. Just answer all those questions. Explain your choices, your preferences, your desires. And if you are a member of any fraternal organization like the Masons or that sort of thing, who may have their own burial rituals, be sure that you note that, but those have to be done prior to the funeral. They cannot be done in the church. They have to be done at a funeral home or someplace else. And if you're eligible for military honors, those should be planned as well. And they will usually take place at the gravesite as part of the gravesite committal. Let's move on to the next slide. Oh, we're way past. Let's go back to the beginning. All right. Past that one. All right. Be sure and instruct your family that to call the church when you die. Call the church office. The prayer book asks that the member of the clergy in charge of the congregation be amongst the first to be notified when a member dies. And then the other thing I wanted to stress on this slide is Episcopal funerals are always closed casket. We don't do open casket funerals in the Episcopal Church. All right, next slide, please. So we're moving into filling out the form now. On the form, fill out all your necessary personal information. Be sure and give your full name, date of birth, all that good stuff. And then of particular importance, how do you want people to refer to you in your funeral? My father had a friend named Wonderful Egeb Jones III, who was known by the nickname Bud. And I'm sure that at his funeral he would have preferred to be called Bud rather than Wonderful Egeb. Anyway, and then you move into the question of your preferred liturgy. Next slide, please. You have a bunch of choices in the Episcopal Church. There's a Rite 1 burial office, there's a Rite 2 burial office, and now there's an Enriching Our Worship burial office, EOW 3. These are all available on this website. The General Convention has redefined the prayer book. We now have, instead of the Book of Common Prayer, we have the website of Common Prayer. And it's everything the General Convention has ever authorized for use in the church, and it's all found on that website. So you can find it there. And then you have to answer the question, do you want to have communion at your funeral? You don't have to. I think most clergy recommend that you do a requiem. Move to the next slide, please. All right, who do you want to participate? Who do you want to preside? Generally, it will be the clergy of the congregation you're a member of. So the cathedral clergy will generally preside, but if you'd like someone else to be involved, provide contact information for them and check with the dean when you're filling out your form, check with that person that they would be available. So next slide, please.
That's an important reminder to check with the dean before inviting out other clergy.
Yeah.
We can almost always accommodate. Sometimes there are pastoral reasons to be careful.
Okay, then the question of music. What kind of music do you want? Do you have favorite hymns? Hymns should be, as it says, confident, strong, joyful, and familiar. There are going to be people at your funeral who are not Episcopalian and won't know our peculiar hymns, so you might want to focus on choosing those that are common across the denominational spectrum. Do you want to have other sorts of music? Now, the one caution is secular music is generally not allowed. You cannot have somebody sing, "I did it my way," or "Another one bites the dust," or, that's just not allowed. So, again, and the canons specifically give responsibility for music to, quote, the member of the clergy, which in this case is the dean. So, just be thoughtful in your selections, and if you have a question, he's the guy to ask. Next slide, please. There should be, these are your musical resources. These, go back to that one we were on. These are the hymnals that are approved for music in the Episcopal Church. And our canons are really strict and say you can only choose from these hymnals. But then there's this line, the member of the clergy has final authority over music. So if you want to, if you want something else, check with BJ, okay? At a funeral, there's usually at least one reading. If you're going to have Eucharist, you have to have a reading from the Gospel. Gospels are read by the clergy. All the other readings can be read by members of your family. Next slide. There are 14 approved translations of Scripture. If you don't like the one we usually use, the NRSV updated edition, and you have a particular version that you like, you can choose from those. Just let the people who are reading know which one to use. And don't mix rites. If you're doing a Rite 1 funeral, do a Rite 1 Eucharist. If you're doing a Rite 2 funeral, you can choose from all those other options that we have. And the last thing is say where you would like memorial donations to be given. Could be to the cathedral, another charity, or something. I'm going to move on now. Ute asked me to say a word about designated gifts. Now, this slide in your handout is out of order. It's at the end of the slide presentation. Designated gifts are those given to a charity for an established purpose that the charity has already designated. You don't actually describe or put the restriction on. You just say, I want it to be used in the flower fund or something. These are generally considered to be tax deductible. They differ from restricted gifts, where you say if you don't use it for this purpose, it defaults to someone else. And whether or not those are tax deductible is up for grabs. The word I would use for designated, or I would give for designated offerings, having done 50 years of nonprofit management, is don't. Please don't. Don't tie the hands of the charity you're trying to benefit. Have some trust in their honor and intelligence and experience. So
you're saying that restricted, you don't recommend restricted and designated
I don't recommend either.
Thank you, Eric.
Ute.
Well, the next presenter is just a heads up that we are trying to hold space for any questions you might have for the last 5 minutes because we realize there's a lot of content to present.
Cheryl, I'm going to let you be the clicker person here. So I do want to have a little caveat before I start the legal portion, which the three of us are going to present to you, and that is we are giving you the Reader's Digest condensed version, and to be very accurate, probably the table of contents of the Reader's Digest condensed version. So please don't think that you're going to find everything you need here. That's not going to be the case. So and also, we are not able to give you specific legal advice, so please don't come up to us afterwards and say, can I have your business card? I'd like you to write a will for me. I'd like you to do a trust. Both Eric and I are inactive in the state of Ohio. We cannot practice. And both Amy and Marie are employed, and their employers frown on them having a private practice. So we're happy to answer general questions, but we can't. But if you would like a referral to an attorney, that is something that perhaps we can do for you.
I am empowered to give you theological advice at any time.
So my portion is why every Christian should have a will. And I liked the little blurb that I saw on the Church of England's website when I was rooting around for information. And it says, we are God's stewards, entrusted to use God's gifts wisely for the good of our own family and all of God's people. So that is one reason every Christian should have a will. There are some practical reasons, of course, as well. And that is, if you want to go to the next one, who should have a will? I think nearly everyone should. So if you care about how your assets are distributed, if you have minor children or pets, which was not on the slide, but I don't have a pet, so it didn't occur to me right away. But some people care very much. Pets are part of their family. If you wish to leave a legacy gift to Trinity or to a charity that's near and dear to your heart, it's important to have a will. So life can be complicated. People may lose a spouse, or maybe your heir or beneficiary passes away. You're divorced, or you remarry after you're widowed or divorced. There's the birth of a child or a grandchild. Or you have some major shifts in your assets. Maybe you buy a condo down in Florida to winter, to get away from the Cleveland winters. Or there are major changes in the law, and those might be coming down the pike. So you have to be cognizant of that. So why have a will or trust? One of the first things that you need to think about is grief. Now, that's not on my slide, but that is what your loved ones are going to be experiencing upon your death. And to add the added burden of not having the information about planning your planning your funeral, or what your wishes are in regards to your assets, is just an other layer of stress that you can avoid putting on your loved ones by taking care of some of this now. So without a will or a trust, your assets will be distributed by the probate court of the county in which you live in Ohio. So they decide. So a will or a trust allows you to choose your executor or your trustee. It allows you to designate the guardianship if you have minor children or pets. It provides a vehicle for making a legacy gift to Trinity or to another charity that's near and dear to your heart. And it's a fail-safe or a backup plan. Regardless of how you hold your assets, a lot of people have structured their assets so that it's transfer on death or payable on death. And I might note that there are some things that do not become part of your estate. Insurance proceeds, for instance, do not flow through your estate. And there are certain other types of things that if there is a designated beneficiary in the documentation for investment accounts or retirement accounts, for example, they do not go through your estate. But things happen. So Amy's going to talk to you more about trusts, but trusts are a vehicle that must be mostly maintained. And if you are not scrupulous about meeting regularly with the attorney that drew up the trust for you and moving your assets and holding them accordingly, you can have assets that do not fall within the trust, and then probate is still necessary. Okay? So you need to think about that. Having a simple will is a fail-safe, essentially. So we're very lucky. For those of us who do not feel that we have sufficient assets that we need to go to an attorney, and perhaps you've seen on their websites, they've been around for years, but they've gotten very much better in the meantime. And they have also been very carefully tailored for each state, because every single state's inheritance laws and probate laws are different. So freewill.com, for instance, one of the first things they ask you is, where are you located? What's your state? So you're in Ohio. So some helpful hints. If you're using something like Free Will, which I recommend highly if you do not have an attorney and you feel that your life is not complicated enough where your assets are not such that you need to go to an attorney.
I thought you were saying you feel like your life is not forever.
Well, that's true, too. We all know that's true. Here are some helpful hints that might help you. So in Ohio, two witnesses are required to witness your will. So don't say, oh, I'm going to take it to the bank and I'll have them notarize it for me. No, not your will. Wills cannot be notarized. Now, Marie's going to talk to you about the advanced directives. There you have a choice. You can have those notarized or you can have two witnesses. But wills in Ohio require two witnesses. So witnesses cannot be anybody that might benefit from your will. So if you're leaving your assets to your husband, he cannot witness your signature on the will to have it be valid. Your children cannot witness. Your cousin, even though the cousin's not named in the will and will not, if all goes well, inherit anything from you, if the will is found to be defective, that cousin is related to you. And in Ohio, that the way your relatives fall in line, first your spouse or your parents, then your children, et cetera, is determined by statute. So you don't want to take a chance that your will would be found invalid. You could have your neighbors. You could have a friend's. Here's the thing people are concerned about. I don't want my neighbors to know what I am leaving or what I have, my assets are. They don't need to know a thing. The only thing they need to know is that this is your last will and testament and that you are signing it in their presence and they must sign it in each other's presence. So again, two witnesses. Keep your original someplace safe, but not in a safe deposit box. Banks are known to close those, and then your executor cannot access it in time. Also, one other caveat before we go, as I wrap up, because Cheryl's giving me the high sign. Please find an estate attorney. Don't go to the guy who had your cousin Joe's DUI taken care of. Don't go to your neighbor's, a real estate attorney. We're specialists anymore, just like doctors are specialists. Find somebody who practices estate or probate law. Okay? So the very last slide, where do I start? There are some additional documents in addition to what you've already received that talk about the types of information that you need to have either in your head as you're going through free will, or you can provide to an attorney to help them structure your will for you. And don't forget about your digital legacy. How do you unlock your phone? What's your computer password? What's your email password? That information is important for your family to have. Okay, thank you very much.
Thank you.
Oh, Amy, you're next.
All right, good morning. Mary Helen wants to take my picture. You got it? Okay. Biggest microphone I've ever held. All right. My name is Amy Wentz. I'm here to talk about trusts. I will tell you that my husband Pete and I are living, breathing members of the sandwich generation, in which we are helping care for our parents and have helped care for Pete's parents as they passed at the same time that we're raising our own kids. And trusts have proven to be an invaluable tool to us both in terms of preparing Pete's family when his parents needed skilled nursing care, which is impossibly expensive, caring for my parents and helping them prepare as they get older, and then also preparing for the unlikely but possible event or untimely event of our death while we still have minor children. So I want to talk, we'll talk briefly about trust. I know we are short on time here. I am available after we end today because I went to the 9 a.m. service. I'm also here every Sunday, and you can grab my number. And if you ever want to talk about the process or get referrals, please let me know because, again, I'm a huge fan. All right, so let's first talk about what exactly a trust is. It is literally just a document. It's a legal entity that in which one individual, the grantor, so gives a second individual, the trustee, the right to hold assets and distribute assets for the beneficiaries. What the heck does that mean? So let me give you an example. And I'll give you a personal example. Pete and I have a trust for our children in the event that we were to pass, both of us were to pass before they're old enough to care for themselves. Pete and I are the grantors. We created a trust. I have a sibling who is the trustee. He would also be the guardian for our children if we were to pass before they're old enough to care for themselves. The kids are the beneficiaries. And so what our trust does is we have funded the trust, meaning we have to fund a trust just means you list things in the document. We have listed all of our assets in this document and given instructions to my sibling. Here's how the money should be spent. Here's how the assets should be spent for the care and benefit of Mary Helen and Bud. So that is the gist of what a trust is. Trust can be used for all sorts of things. You probably hear about people who have, children of wealthy families who have trusts that are made available to them on their 21st birthday. Those are all sort of examples of ways that you can set up a trust. But this would be the sort of most simple way for the purposes of what we're discussing today. All right. So what goes in a trust? Pretty much anything that has a title or you have some proof of ownership, right? So a bank account, property, if you have jewelry that is worth of, anything that you own, a car. I know the kids are dying from my 2019 Volvo. Yeah, okay. And when we talk about funding a trust, again, literally the trust is just a document. And when you're funding it, you're literally listing out the things in this document that you want to go to certain people. All right, let's go to the next. So how does it actually work? A trustee can actually spend any of the assets before you die. And so one of the things that you'll do in a trust, we did this with my parents, for example, is my parents have a trust set up. My brother and I are listed as the executor and trustee. I don't know which is which. But if, for example, one of my parents dies and the other is incapacitated, the trust would give us the authority to spend their resources to help care for the incapacitated parent, even though that person hasn't passed already. And that is a key benefit of a trust over a will, because wills only go into effect after you die. The trustee or the trust document has very strict language about how the trustee can spend the resources. So I've named a sibling as the trustee. He can't necessarily show up and start writing, checks out of our checking account, for those who still write checks, to take his family on vacation. There's rules in in that document about how that money can be used and how it can be spent. And importantly, the trustee has a fiduciary responsibility. It's a legal responsibility to act in the best interest of the beneficiaries. It's not a slush fund for the trustee. That's not to say that you don't want to choose somebody that you trust to be your trustee, but you want to find somebody who you trust will act in the best interest of the beneficiaries. So Ute talked about a will, and so what I did is I prepared a slide here for you that sort of identifies the differences between a will and a trust, right? So they're both documents that basically give a to-do list to your executor or your trustee as to what to do with your stuff, either once you die or before you die. There's two primary distinctions. As Ute mentioned, wrap it up. Okay. The wills are subject to a probate. It's a court process that can take upwards of 18 months. Think about passing and you still got minor children. You don't want your guardian to have to wait 18 months before they have access to your financial resources to care for your children. So probate, while serves a very good process, it's just a court process that oversees the distribution of your stuff. A trust just goes into effect as soon as you sign it. They don't have to wait for probate. And importantly, the will is where you provide for the guardianship of your minor children and your pets, if you still have them when you die. And then the trust can serve lots of different I'm going to keep going because in the interest of trust, but there's something called a revocable trust and an irrevocable trust, and they serve different purposes. And if you go talk to a lawyer, they'll walk you through what is in the best interest, depending on what your estate looks like. So who should have a will versus a trust? As Ute said, everybody should have a will. If you've got stuff, you should have a will so that when you pass, people know where you want your things to go. People who should have a trust, that was a will. People who should have a trust are individuals with minor children. You want a will to say this is where I want my children to go, but the trust is the instrument that ensures that they'll be cared for with your resources after you've passed. Also, if there's any concern in your family that you might become incapacitated or that your spouse might become incapacitated after you die, a trust is a good tool to set up to ensure that person, so for example, Alzheimer's runs in the family, or you've been diagnosed with dementia and you know that it's going to progress over time, a trust will ensure that you will be cared for with your own resources by somebody whom you trust. Okay. And then these are just sort of some key considerations to think about. Most importantly, wills and trusts are not mutually exclusive, right? Pete and I have both. We have a will that identifies what happens if one dies before the other, which is we inherit everything. The surviving spouse inherits everything. But then we also provide for what happens to our children if we were to both die. Wills, you can do them for free. You can get them off the internet. They're fairly not complex, but they don't serve as many purposes as a trust will. A trust is going to be a little bit more expensive because you have to you got to pay for an attorney to do it. But there's more detail in the trust that will ensure that your wishes are carried out and that after you've gone, that your assets are being distributed in the manner that you wish. And that's it.
Oh, thank you for this huge microphone. Hi, I'm Marie Curry. I don't know. I've been around for a while. I'm not a newcomer. We actually just redid my mom's paperwork. She was in Florida with my father for a long time. He died over 10 years ago, and we hadn't redone anything. And she moved to North Carolina, and my sister works as a paralegal for at a law firm in North Carolina, and so they helped us redo everything. And he was kind of aghast, like, oh, my God, you haven't fixed all of this? And so now it's all North Carolina, state stamp of approval. And we have her trust. Everything goes, actually, we funded the trust. Everything that she owned, we had to retitle, basically. Like, she closed all of her bank accounts. Now they're all bank accounts in the name of the Marie B. T. She's Marie T. Curry. I'm Marie B. Curry. Marie T. Curry Revocable Trust. And so everything goes into there. And we had a whole list of things that we had to do, and slowly but surely we moved everything into the trust. So it's a chore that you need to keep track of, but we feel really, really good now about where everything is. And she's 86, so she could live another 15 years or not. So advanced directives. So I have the easiest part of this deal today. Go ahead. We're going to talk about advanced directives, and they're basically a legal document that details what you may or may not want to have happen in the event you can't advocate for yourself, right? If you can talk and say what you want and you're competent, you're good. But if those things are not the case, then you might want to have in place something that either somebody who makes that decision for you or you make clear what you want. So the most widely used are living wills and powers of attorney. There's two different powers of attorney, one for healthcare, one for financial. Turns out in North Carolina, they're the same document. I don't think of them as the same document because that's not the way that I use them in Ohio. So go ahead. So we're going to talk about two things, living will and healthcare power of attorney. And the living will is the document that tells your doctor, right, or your healthcare provider what you want or don't want to keep you alive in the event you can't say so yourself, right? It can include other kinds of details about what you want to happen, but the key piece is if I can't tell you myself, this is what I want you to do or not do to keep me alive. Go ahead. So this is who can make a living will. You have to be an adult. You don't have to be ill. Everybody should really. This is a document that everybody should have. And let's see. And you can always update this, right? It's not like set in stone. I think. Well, I'll leave that to later. Go ahead. So this is not a hard thing to do, but you have to think about, okay, what do you want, right? What do you want to happen? Do you want food and hydration if you're incapacitated? Do you want, is it different if you have a terminal diagnosis versus if you're in a persistent vegetative state, right? So these are, and so. You want to know what you want to put into your living will when you sit down to put it together. Then you can also think about, okay, what are the other things that I might want? Do I want to be intubated? So we know what intubated means, right? Do you want an airway created for you if your airway is not clear? Do I want to donate my organs? Go ahead. Oh, wait. So in Ohio, boy, we're moving fast here. She's moving us right along. In Ohio, there's this fantastic form, which I really, really like. It's in your packet that you had on the chairs, and we'll look at it in just a second. And as Ute said, I think it was Ute who said this, that it can be either notarized or witnessed by two people. Similarly, you can't use a witness that is named in your healthcare power of attorney, or who is a family or a healthcare provider or a guardian or the nursing home administrator, right? Nobody who might benefit from your demise. And you should provide this to your healthcare provider. My healthcare provider has asked me the last few times I've gone in, do you have this? Can you bring it in? So the form in your packet is the fill-in-the-blank form. You can also find it online. So the second piece that we're going to, and I just want to give you like the table of contents on, basically, is a healthcare power of attorney. And you can see I'm not from the Midwest. I talk really fast. So I can't even read this. So I'm actually hoping, Cheryl, that you'll share these, that we can share these slides somewhere where people can print them out or look at them in a full screen mode. So the healthcare power of attorney is the person who acts for you if you can't speak for yourself. Thank you. You can have, again, both a healthcare power of attorney and a living will, and they can both be used. Right? They're not, again, mutually exclusive. They're used for different things. So the healthcare power of attorney is something that you're naming someone, right? You're naming your attorney, in fact, your person who's going to tell the healthcare provider what to do in a particular situation. Who can serve? Go ahead. Who can serve? Most often they're relatives. However, it's not required. Generally, any competent adult. When my kids turn, I've said this probably before in here, when my kids turned 18, I sat them down and said, we're going to sign these forms because I don't want any issue if you're in the hospital and I need to come in and say, here's what's going to happen here. Even though I don't think that hospitals are in the habit of, like, turning parents away, I just didn't want there to be any issue. And my daughter, who's very, she says, well, is this forever? And I'm like, no. When you have somebody else that you want to do this, that's fine. We will make that change. But for now, it's me. And it turns out she got engaged last weekend. So I'm pretty sure that's coming down the pike. New forms. That's so true. Okay, so go ahead. So the duties. So the healthcare power of attorney. That person makes the healthcare decisions on behalf of me when I can't do it myself. But that person's supposed to act in accordance with what I want. And there's no filing requirements anywhere. And it doesn't take effect until the principal is no longer able to make their choices on their own. Go ahead. So these are how to create it again. There's this great form, notarized or witnessed. Let's see. So those are kind of the high or level overview. Here's the summary. Similar, must be notarized or witnessed. Different, describe the wishes of the person. Signing for what kind of medical treatment they want if they're incapacitated. And the other is name someone to make decisions on their behalf in accordance with your wishes. The form, which I have like 2 seconds, it looks like this. Okay, it's this packet. It's from it's got the Ohio State Bar stamp of approval, but I get it from the Pro Seniors website. And again, I really, really like it. But what I want you to think about as you're going through this is there's all these places where's my camera? Where there's this little box here. And those are the boxes that are kind of, okay, over and above the basics. If you want this to happen, you have to put your initials in that box. And there's all the things that we want to make sure people are not giving away without really intentionally realizing that they're giving it away. And you'll notice as you read this form or as you look at this form that it's a fairly high level of literacy required to get through this form. So again, it's the reason why you might have somebody help you walk through this. But it is a form that you do not necessarily need to have an attorney to complete. I think I should stop, yes?
Thank you.
Yes.
I just want to say quickly before we take on, you realize that each of the subjects that have been presented are weighty subjects, and they deserve sitting with them for a while. We are intending to give you a brief snapshot of some of these very important facets of the state plan. So we do have larger print slides that are available for folks who would like those before you leave. I just have to run to my office. You can reach out to us to follow up with us about any of what you've heard, and we are happy to talk to you about and give you some suggestions for next steps.
Yes, thank you. There are so many layers to this, and I think one thing I heard is there's in all of these categories there's a basics, a basic level that you really want to think about, because without that it can be problematic. But you can expand to think about trusts. You can think about a basic funeral and expand to bring the Cleveland Symphony Orchestra in for the service, however you want to do that. But what questions emerge? And I know some of our people can stick around for a bit. Jeff.
One real quick point I would make with regard to the healthcare power of attorney and advanced directives is they need to be available for the use of the healthcare provider. And we ran into this issue when my mom got sick in Florida. I am not her primary healthcare power of attorney, and they needed to know who was. So there's a magic formula. It's on. Put it on your phone. Take
Oh, right.
Stuff and then your own stuff, and put it on your phone. You will have it. It's legal. It works.
All right. Thank you.
And somebody needs to know the code to unlock your phone.
Right, right. Digital footprint, people. Digital footprint. Please.
I'm not shilling for any particular lawyer in particular, but if you retain a lawyer, they will walk you through all of this. They usually charge you a flat fee. You'll go into it exactly what it's going to cost. But when we did this, we got the will, we got the both powers of attorney. They're 2 separate documents in Ohio. We got the trust. and the advanced directives. Everything was covered. And so we knew walking out of it, here's the packet. She even gave us a to-do sheet, like you need to, put your bank account in this number, and you need to do this with your life insurance policies, and you need to send this to the trustee, like put it in the mail and mail it to this person. And so I feel comfortable, like when my parents go, we're all on the same page. When Pete and I eventually get called home, our kids will be cared for. So consider hiring a lawyer if you can. Yeah. So, how much? Do you remember? How much does it cost? I think my parents just did it, and I think they paid $3,000. And I also recommend looking for a lawyer who's not in downtown Cleveland or downtown Akron, because they're going to have higher overhead. So look for a lawyer out in the suburbs.
I would add the Ohio Supreme Court does also. Thank you. The Ohio Supreme Court does also certify attorneys who have had additional training and pass additional exams in a specialty area, and estate planning is one of those specialties. So you might ask, and I agree with Amy completely. Please don't go to a general practitioner who does mostly criminal defense work or real estate or whatever. This is a very specialized area of practice, and your money will be much better spent. It's not an exorbitant amount. Wills, as Amy said, if you get a will done with an attorney and they do not provide you the living will and the health care power of attorney, and at least suggest to you that a trust might be applicable given your circumstances, they're probably not doing a thorough job for you.
To any member of the panel, go ahead.
Yeah, quick question. Are trusts filed with probate? Where do they do the filing?
Trusts are filed with anybody. Yeah.
Okay.
A trust is simply a document that you give to the trustee to say, if I pass, here is what happens. So the act of signing that trust creates the legal entity, and then it's your job to, where you say you want to go through your bank accounts, and you're going to put them in the name of the trust. It's a little more detailed than that, but there's a way to sort of fund that trust so that in the event of your passing and you need care for your kids.
It's the will that you might file with your county.
Yeah. Your trust is not a public document, so nobody needs to know about it except those involved. And you might be asked to show your trust or to give a copy of that to a financial institution, for example, when the assets are being accessed. A will is a public document. It is filed with your probate court. Now, they don't put them on the website, so I want to be very clear. Okay, my son Nick works for the probate court, but people can go down to the courthouse, and if you have enough information, you can have them look up the will of a deceased individual. It's
only filed with the court after you die.
After you die. No, not before. It can be filed in a sort of a holding pattern. They will take it and file it for you, but that is not accessible until the will is probated. So my mom's will is probably down at probate court, but we did not probate her estate because we were able to have all her assets transferred in a different way prior to her death. Okay?
Can I just add trustee? I just want to add one thing about wills and trusts. They are not, as Amy said, alternatives. If you have a trust, you ought to have a will as well. As soon as you sign your trust and put everything you own into it, tomorrow you're going to acquire something else that won't be in the trust. So you need to have a will. Yeah, you need to have a will to pour everything over into the trust when you die.
And people do have trusts that are activated in their wills. So another instance that Amy, I think, has on her slides but didn't talk about was if there is someone in your family with a disability which would make it impossible or difficult for them to have those assets they're going to receive, a trust is an excellent way to do that.
I'm going to have Cheryl take over my spot because I've got to get to church. That was I was going about. Okay.
We have one more question in the back of the room.
Is a trust always just one individual, and can you name an alternate in case the trustee becomes incapacitated?
You can name alternatives. For example, Pete and I did that because there's a chance that the trustee declines. Right? They may not want that assignment.
Barbara has a question.
Well, I have a comment. Our children gave us a knock box, N-O-K, next of kin box. It's a box that has files for all these categories where you keep the notes of where each of these documents can be found.
Right.
So I'm
That's a wonderful
working
idea.
on the knock box, but it's not easy.
That's a wonderful idea. And just as a reminder of what Eric and several of our presenters have said, the two can go together. Everybody should consider having a will at bare minimum. And I hope you heard a little bit today about the areas of vulnerability or risk when we don't have one. Sometimes there's a presumption that if you're not a member of AARP, you really don't need a will. If you're not in your 50s or 60s, you don't need a will. But if you have minor children, you should think about what might happen to those kids if something happens to you. You need a will. So, and I do want to say Trinity Cathedral has partnered with Free Will to provide an online resource to help you walk through the process of creating a will. Ute and this whole team has been helpful for me in making sure we pay attention to the regulations in the state of Ohio. So, and what Ute said about in Ohio, your will doesn't need to be notarized. Well, I took mine to the bank with my healthcare power of attorney thinking, here, just put your stamp on this for me. And the person at the bank said, oh, I can do this. Sure, but I can't do that. So that's Ute's lesson about wills are not to be notarized. They're to be witnessed by two people. So we want you to consider, you can go to the Free Will, Trinity Cathedral's Free Will site, and go through the process of drafting a will and not formalize it. You can draft a will on that Free Will website and print it out and take it to an attorney to talk through further. Whatever you put on the Free Will website is confidential unless you flag that you want Trinity Cathedral to be aware of it. Also in the back of the room, there is an asset inventory resource to help you think through what your assets are. You might be surprised. You may have come into this room thinking that you don't have very many. Maybe you think you have a house. Maybe that you think that's all you have. But this lets you sit with some potential things you may not have thought about as assets. So if you haven't picked up one, I think some of them are wrapped in the Legacy Circle brochure that promotes the Legacy Circle for planned gifts to Trinity Cathedral. There also are some extra ones on the back. In addition to the form that Marie gave you, there are extra living will forms that you may pick up and use that our presenters have made available, and thank you especially to Marie and Ute for those. There's healthcare power of attorneys there as well. And be mindful what Jeff said. Healthcare power of attorneys, I think Marie alluded to this, they only work when your healthcare providers are aware of them, when your family is aware of them, and when the people that you've selected to have oversight for you are aware of them. So I want to just really give a round of applause to our presenters, and they've done a remarkable job. I have a sense that we could have had a dean's forum on any one and probably all of these topics one at a time. But we want you to know that we want this type of conversation to become a part of Trinity's DNA, a part of our culture, that we're always having these conversations. So thank you for coming, and keep your ear to the ground about the next conversation. If you need any additional resources, any of the forums we talked about today, just follow up with any of the people you see. Even though they can't provide legal advice, they can steer you perhaps to where you can get forms and documents that are online.
Cheryl, I wanted to say I can't give legal advice, but I can give liturgical advice. So if you have questions about planning a funeral, I'll be happy to answer them.
Any additional questions you have, please feel free to shoot me an email. If I don't know the answer, I can pass it along to somebody who does. Thank you. Have a wonderful day.